So now we are going to go to those who very kindly report on the panels and workshops that we had yesterday. I'm going to take it in the order I have here, but each has an opportunity to report back very simply what was said, how it was, how the separation of powers discussion went in their workshops. And then if we have some time at the end, we can perhaps draw some strands together. But I'm going to start with Christina Voigt, Professor, Department of Public and International Law, University of Oslo. Christina, why don't we have you go first? I can't see you on my screen, but I'm sure you're there somewhere.
Thank you, James.
Oh, gotcha.
I see you on my screen. Thank you, James. And a warm hello to everyone from a very summery afternoon in Oslo here in Norway. Yes, I have the honor to report back from our workshop yesterday on the role of judges, which was facilitated by Professor Dana Shelton and Justice Emmanuel Ugira-Shebuya. And we had a number of justices and judges and extremely rich discussions. And we all felt that we were just scratching the top of the iceberg. There was so much more to discuss. And I can never do justice to the rich discussions we had yesterday. So I will just very briefly try to report back on three main issues that we spent quite a lot of time on. The first one is we discussed the role of judges in climate litigation. The second are the parameters within which judges operate when they have climate-related cases before them. And the third aspect is what are actually the outcomes, the desirable outcomes of cases. So let me zoom in on the first issue. Do judges have a role to play? And here there was a profound understanding, pretty much shared by everyone in our workshop yesterday, that judges not only can or should participate in climate-related cases because they're more flexible or they're independent from the judiciary, from the legislator, but judges are obliged to do so. It's not just a voluntary thing. It is also a mandatory, it's an obligation. They're obliged to do so, but within the limits of their authority, of course. And what are those limits to judicial authority? Well, first, there is a role for judges to play where the legislator was inactive, where the legislator just did not adopt any laws or regulations, in particular in situations of social stress, of social challenges. But a second role of judges is to clarify the meaning of existing laws, to clarify the law, the obligation, the rights, where they are ambiguous. And a third role of judges and of courts is to move the law forward, because law is a social construct. It is not set in stone. It is at all time relative to social circumstances, and laws, judges and courts always have moved the laws forward. There's also a role of judges to develop a common framework of reference for climate litigation, in particular, applying certain principles, applying certain standards, but something that the judiciary, but eventually perhaps also the legislator can relate to. So now to the common parameters. So we agreed there was a role for judges, and they were even obliged to get active. Now to the parameters within the judiciary operates. Well, first of all, there was the question of jurisdiction, and everybody agreed that there's always a need for a legal hook. Judges cannot just make things up. They have to have a legitimate anchorage in the existing legal framework. So they have to act within the existing law, whether it's constitutional provisions, whether it's sectoral law provision, whether it's a general duty of cooperation or a general duty of care, as we, for example, have in the Dutch cases in the tort law, which is an unwritten duty of care, but there is a legal hook, or it is human rights law. And we discussed human rights law quite extensively because we have very few jurisdictions. We have no international recognition of a right to a clean and healthy environment, but we have several domestic and subnational jurisdictions that recognize such a right on their national scope. On the regional jurisdiction, we had a justice from the European Court of Human Rights. Of course, we all know that the European Convention on Human Rights does not recognize or does not contain a right to a clean and healthy environment, but that the existing rights, right to life, right to private life and family life, Article 2 and Article 8, and right to non-discrimination property rights, that they are being interpreted in the light of the current climate challenge, and that the European Convention is a living instrument, and it can be done so because it is not set in stone. But also there are limits to it. You cannot just interpret a human right to clean and healthy environment into the European Convention on Human Rights, but there are ways around it. We also discussed the temporary or a temporal and spatial dimension of rights. Temporal dimension, of course, is incredibly important, as we just heard from Mr. Stiglitz, when it comes to those that are young today, but are living into a future which will be marked by climate impacts, or those that are not born today, they're not born yet, future generations. And we discussed the judgment of the German Federal Constitutional Court, which established an intertemporal application of certain liberty rights in an innovative move, something that wasn't done before, but it was in order to give recognition to the rights of the people that are young today, but are living into an uncertain future. Also, the spatial dimension is very important, especially with regard to extraterritorial implications of climate change, where those that cause or have the responsibility for reductions or cause significant climate contributions are in one place of the world, but the victims are in another state, in another place. And here the legal system meets some challenges, some limitations, and we discussed how that can be addressed and how that can also be overcome. We also discussed issues of causality, where it's still very difficult to trace back one particular climate event to a particular emission of greenhouse gases. But again, there are legal ways around it in terms of percentage contribution, also development of attribution science, which is up and coming, or partial contributions to the problem. And the third, the final parameter we discussed are issues of proof and reliable scientific data. And here, of course, the reference was made to the reports, the assessment reports and special reports by the IPCC, but not only, there are also national institutions that provide reliable science processes, peer-reviewed articles, and so forth. We heard from Pakistan that the court there, the Supreme Court uses a committee, a scientific committee in its deliberations. And there was also a suggestion to maybe use or even have a scientist on the bench with the relevant background. We heard from South Africa that impact assessment reports themselves were being used by claimants to point directly to the significant environmental and climate impacts, for example, of new mining concessions. And my final point goes to what should be the outcome of a climate case. And here we discussed the co-positioned structural injunctions versus concrete requests. And structural injunctions basically means that the ball is being played back to the legislator to do better. And that, of course, can also be difficult because it brings back the question of how to balance, again, the judiciary with the legislator competences. But this is what we're mainly seeing in current climate cases, that governments or companies are asked just simply to do better in light of certain findings by courts. And finally, we have some, but these are maybe the exceptions, some cases where courts tell exactly the governments what to do in terms of percentage, for example, the agenda case or the Shell case, but these seem to be the exception to the general rule of structural injunctions. that was our broad discussion, and I was happy to report back to you.
Lots there, Christina. Thank you very much. Got some notes. If we can, I'll come back to a few points, but let's just get through the list so we get the reports back from everybody. Michael, you're next. Michael Gerrard, please. You report back from your session.
Thank you, James. So I was the rapporteur at another workshop for judges. This one was facilitated by Judge Brian Preston of Australia and Professor Pilar Morago Sariago of Chile. This particular workshop was held at 6 p.m. to 8 p.m. Eastern time. And so in view of the time zones, we had good representation from South Asia and the Pacific, as well as South America and the US. The courts in these regions are issuing many forceful decisions, compelling governments to act more strongly on climate change. The judges involved said that they felt they were not violating the separation of powers or deciding a political question, because they're basing their decisions either on the national constitutions or on statutes that had been enacted or treaties that had been ratified by their parliaments. And thus they were carrying out the constitutional duty of judges to interpret and enforce the applicable law, even if the politicians of the moment do not want to do so. The judges felt that even though their decisions may have very significant consequences, they felt they were not venturing very far into new areas. They were just applying existing law as they saw it. And in many of these views, I have to say this is very consistent with what we just heard from Professor Voigt about the panel on which she just reported. There was some acknowledgement that if the courts issued decisions that to the public seemed to be too aggressive or too outside the bounds of the normal, they will face pushback, and there could be a loss of confidence in the judiciary, and most importantly, that the orders they issue might not be carried out. So some felt that the proper role of the courts could be to engage in what Professor Joseph Sachs called the legislative remand, where the courts say that the current law is broken and the courts cannot fix it, but the legislature should. That could raise to a high position on the public and legislative agenda these issues and hopefully get action. On the other hand, there's the possibility that if judges abdicate their responsibility to act in the face of the crisis, that too could lead to a loss in public confidence in the judiciary. There's a growing concern in the public and the news media, of course, about the severity of the climate problem. But in many places, the legislative and executive branches have been negligent in not addressing the climate problem, possibly because they have been captured by fossil fuel interests. And so the legislative remand does not work. And so there was a sense by some of the judges in our workshop, not all of them, that judges then have not only the ability, but also the obligation to step in and prevent global disaster. The power to do this can be found in the objective that implicitly underlies all national constitutions, that the state shall survive, civilization shall continue, and people will be able to keep on living their lives. If these things are in danger, and if the other branches are not acting, the courts must step in. That was the view of the trial judge and the dissenting appellate judge in the Ninth Circuit in the Juliana case. But of course, the majority disagreed. Another question that was discussed concerns remedies, as we also heard from Professor Voigt's panel. We've seen quite a few cases where the courts declared that some constitutional or human rights obligation has been violated, but they offer no remedy other than a declaration of a violation, again, deferring the solution to the legislature and the executive. We also now have quite a few cases where the courts issue a mandamus telling the government to perform some non-discretionary duty. We now, as we have heard, have several cases where the courts set a numerical objective that the government needs to figure out how to meet, or the such as we've seen in the Netherlands and France and Germany, or a private company needs to figure out how to achieve the objective, the Shell case in the Netherlands. We have very few cases that specify where the courts specify how the objective is to be met. That's the domain of experts, and specifying the implementation details could indeed cross the line set by the separation of powers. There was also a variation in the degree of supervision the courts would use in supervising compliance with their rulings. There was also a sense that a dialogue among judges from different jurisdictions, such as at these workshops, is very helpful in sharing ideas, theories, and methods. On this theme of sharing information, let me take this opportunity to say that many of you know that the Sabin Center maintains a database on which we attempt to post all of the climate change cases around the world. And many people have told us that they frequently use this database. So I have one request of the attendees of this conference. If you know of climate change cases that should be in our database of climate change cases, but are not, please send them to me. We want to be as comprehensive as possible. It's challenging to capture everything, especially decisions written in languages other than English. I'll put my email address in the chat together with a link to our database if you don't have it, and a link to how to receive monthly updates. We'd really appreciate your help in keeping this database comprehensive and up to date. Thank you.
Thank you very much, Michael. That's terrific. Lots there too. I've got, it's a nice sort of almost collegiate handover now to Mike Berger, but I can see, Joana, you've got a hand up. Did you want to say something at this stage? No, okay, it just appears on my screen. All right, so Mike Berger, Senior Research Scholar, Lecturer in Law and Executive Director at the Sabin Center for Climate Change Law, Columbia Law School. Over to you.
Thank you so much, James. So good morning, or good afternoon, or good evening. I'd like to say a quick word of thanks to the organizers and to the other speakers and the facilitators and the participants in the workshops yesterday. It's been a remarkable set of conversations already, with more to come today. Our workshop focused on the dynamic relationship between climate litigation and climate science. Last year, I, along with colleagues at Columbia's Lamont Earth Observatory and the Sabin Center, published a paper titled The Law and Science of Climate Change Attribution, which sought to survey the various ways that attribution science has and may figure into climate law and litigation. This past year, just to plug another Sabin Center resource, we also launched a new website, climateattribution.org, which I'll also put into the chat, which makes selected and a broad range of peer-reviewed papers and non-peer-reviewed papers with what we believe to be legal salience available through a searchable database. So it was a real joy for me to be joined by the scientists, lawyers, and scholars who gathered to discuss this critical set of issues yesterday. The role of science in climate change litigation is not uniform, either as to the different stages of litigation or to the different types of litigation. The conference background paper notes that there are more than 1,800 cases that we have collected in the Sabin Center's databases that Professor Gerrard just mentioned, and that these are cases that we count as climate change litigation, which for our purposes means that climate change is a material issue of law or fact in the case. The vast majority of these cases are cases that seek to determine the role of climate change, whether the role that it might play or the role that it must play in implementation of existing statutes and policies. The types of cases where separation of powers is most prominently at issue, constitutional or human rights challenges to the failure of governments or major corporate actors to address climate change on a economy-wide or large scale, reflect a relatively small percentage of cases. But the fact is that climate science is central to all of the cases. Our panel explored 4 questions. How does the judiciary consider and apply scientific knowledge in climate lawsuits? Can courts require that science be considered in the making of climate-related public policy? Can science be used to facilitate courts in taking a more critical role in shaping climate-related policy? And should the state of consensus on science determine the nature and extent of the exercise of judicial oversight? Our discussion launched with recognitions of several distinctions that raise the question of whether these questions can be answered in an authentic and coherent way. In one sense, there is not a judiciary at all, at least not in the sense of a singular entity that is governed by uniform norms, principles, or rules of decision or procedure. Legal systems are always very specific at the regional, national, and/or subnational level. These specificities have procedural and substantive elements, which will determine what the role of science is in any particular case, if there is any role at all, and under what conditions. International courts are also highly variable and may possess more or less discretion as to how to handle and whether to consider the climate science. There are also different kinds of climate science. There is attribution science, which seeks to understand whether human activities affect the global climate. There's impact attribution science, which seeks to understand how changes to the global system affect interconnected natural and human systems. There's extreme event attribution, which seeks to understand how climate change is affecting the magnitude, frequency, and other characteristics of extreme weather events. And there is source attribution, which seeks to understand to what extent different sectors, different activities, and different entities, whether they be countries or individual corporate actors, contribute to anthropogenic climate change. In all of these contexts, peer-reviewed scientific studies and the IPCC and national assessments of them dominate the legal discourse. These studies lead to higher degrees of confidence and certainty, and eventually, hopefully, a consensus view, which judges can then readily rely upon in making their judgments. Cutting-edge research, new research, or otherwise less well-established methodologies can win in court if they prove persuasive to a judge or a jury. But the battles of the experts that emerge, the contentiousness around what is known and unknown and how, can produce less judicial confidence in taking bold action. Importantly, there is the risk that traditional environmental knowledge may be excluded from the construction of this consensus and from the courtroom, and scientists and litigators alike have been increasingly focused on protecting against this bias, though there remains much, much, much more to be done. So when does science matter in the many different contexts and many different moments in climate litigation? There is no question that climate science matters for courts' separation of powers analysis. The separation of powers represents a key threshold question. Does the court have the power, the authority, the legitimacy in taking action? In the much discussed Juliana case, the United States, in the United States, the federal government's challenge to the remedy that the plaintiff sought, which was a court order directing the federal government to develop a comprehensive plan for climate drawdown and then implement that plan, invoked challenges to plaintiffs' claims that climate change caused particular injuries for the particular individual plaintiffs. Some of those injuries were associated with extreme events. Some of them were associated with public health impacts. Some of them were associated with availability of water supplies, as well as challenges to the method of attributing domestic emissions to the government itself. So we saw both impact attribution as well as source attribution front and center in that threshold moment. Similarly, fossil fuel companies defending against nuisance and other lawsuits in the United States have challenged the very notion that they can be held responsible for emissions associated with their products, so-called Scope 3 emissions, which are consumed and combusted by people all around the world. Ultimately, whether a case is justiciable, whether it passes this preliminary separation of powers threshold, may hinge on the way a judge or a set of judges understands the basic elements of the nature of the risk to people and places, the extent of the defendant country or company's contribution, and whether a remedy will actually do anything. Importantly, though the discussion of climate science often tends to focus on climate change mitigation, separation of powers in climate science dynamic is also directly relevant to cases involving adaptation or the failure to adapt. These kinds of questions about the nature of government obligations and corporate responsibility do arise in the adaptation context as well. Do national and local governments have an obligation to relocate people who are at existential risk? Do they have an obligation to prohibit development in high-risk areas that within 30 years will be inundated? Do they have the obligation to require specific safety standards, if not something more? Science also matters once that question is answered, assuming the answer is yes. Perhaps most importantly, science will be necessary to answer the questions of foreseeability, causation, and apportionment in resolving cases. Legal and ethical principles will factor into these determinations as well, naturally. The law is perhaps more advanced in the area of prospective responsibility, cases where courts have held countries or companies responsible for higher levels of climate ambition moving forward. The law on retrospective liability is still young, and many of us will be watching and litigating and judging those issues in the years ahead. Now, I'll close out by just noting a few of the emerging areas of science with potentially high salience for climate litigation that were raised in the course of our conversation. Effort sharing, the scientific effort involved in translating geophysical limits into national responsibility. The science of climate inaction, which involves social science investigating corporate knowledge of climate change and the impacts of that knowledge on the climate crisis. Intergenerational impact attribution, comparing impacts to be experienced by today's youth and future generations with those experienced by today's older generations. Intragenerational impact and source attribution, comparing the differential impacts differently situated people endure today, not only to expose and comprehend the inequity of global climate change injustice, but also perhaps in the context of transnational litigation. And then finally, negative emissions technology. This is an area where there may be less current scientific certainty or understanding, but where rapid development may radically affect conceptions of obligation and liability. Now, I'll conclude very, very quickly, James, with there's wide agreement that the language of scientific communication matters. The law provides for very particular kinds of audiences, judges and juries first and foremost, but also the body politic that's looking on. It provides for particular structures and expectations when it comes to the communication of the science. And there is nothing unfamiliar to the courts or to the law about climate science. Notions of factual causation, probabilistic causation, risk assessment, contribution, and so on are all well established. It will be up to the litigators to communicate this best science to the courtrooms, and it will be up to the judges and courtrooms around the world to apply that science to decide the cases before them. Thanks.
Thank you, Mike. And just another reminder too about the importance of communicating in more than one direction at once, inside the courtroom, outside the courtroom, different audiences. Okay, next, David Driesen, University Professor, Syracuse University College of Law. David, can you report back on your workshop, please?
Sure. Well, our workshop was led by Dan Esty and Ian McNeil, and it focused on the effects of climate change and the litigation around climate change on private markets and private actors' responses. And I'd say the consensus was that litigation from the perspective of fossil fuel companies is a dark cloud that is beginning to influence companies through multiple routes. That influence is not yet huge in the United States. It seems to be larger in other countries. And while our focus was on private markets, there is a relationship between the rulings that are sort of at the center here, where courts are ordering governments to do things, and private decision-making. And the example was given is the ruling against Royal Dutch Shell. And so you see this, for example, the combination of the ruling against Royal Dutch Shell and shareholders demanding changes in Exxon's board are beginning to influence companies. And the 2018 litigation has led insurance companies to strengthen their efforts to take climate disruption into account in actuarial calculations and deciding what risks to insure. Investors with fiduciary duties are now commonly taking climate risks into account. And also, while litigation may not have caused rapid transition away from fossil fuels, it has stopped some projects, but it will do more when companies face liability, which can be expected sooner or later. Currently, there's little private law to create liability for emissions, in spite of lots of disclosure obligations in some countries, and France particularly, for instance, cited as an example of a country with a rather robust disclosure regime. In the United States, our regime is less robust, but the Biden administration has signaled a desire to strengthen our rather weak disclosure requirements. And litigation's impact then can increase if we have laws that create private liability, like a general duty of responsibility that some workshop participants were advocating. Private litigation also can have some sort of unexpected ripple effects that go far beyond the case itself. An example that Michael Gerrard brought up actually was dicta in a US case suggesting that banks have responsibility for hazardous case cleanup, led to banks becoming very concerned about how companies, letting it influence their lending, what was going on with potential hazardous waste liability. On the other hand, another workshop participant pointed out that litigation can be suboptional, as it does not provide the stable investment climate associated with carbon pricing. Public law cases like the ones featured in this workshop can influence the liability of corporations in private law. An example of this that one workshop participant cited is that the Dutch Shell case, which put liability on one particular company, relied heavily on citations to the agenda decision. So that there is some cross-fertilization there. In terms of separation of powers, there are some countries, and the US and England are maybe the strongest examples, where separation of powers concerns make it very hard to use private law unless the law has clear standards that demand very little in the way of policy judgment from the court. But separation of powers concerns and the way that's envisioned vary from country to country. And some participants pointed out in the global South, judges are much less concerned about separation of powers and are much more concerned actually about standing up to large corporations. And for that reason, it might do better with laws that shape investments rather than stop particular projects in some circumstances. I think a lot of our discussion focused on the multiple pathways with which climate litigation and climate risk can influence private markets. And I mentioned some of them already. It can affect insurance. It can affect shareholders' decisions about whether to invest. And there was some emphasis on the fact that fiduciaries these days feel an obligation to take climate risk into account. It can affect consumer purchasing decisions. And it's increasingly, and this is sort of new to me, affecting central bank regulation, disclosure, and business planning. So litigation is beginning to have an impact on central banks. They now consider environmental criteria in making decisions. They need better metrics to do this well. Central banks stress testing may look at climate risk. Also double disclosure, where companies must not only disclose the risks that they face, but the risks they're imposing on society can influence consumers. And already companies that use coal cannot be viewed as sustainable under ESG criteria. So the general lesson is that this litigation is having an impact, and it can be expected to have more in the future. And the way separation of powers concerns affects that litigation will vary by polity.
Great. Thank you very much. Thank you very much, David, indeed, for that summary. Lots to note there. Lots of this multiple pathway approach is clearly of great interest. And there are cases coming forward now more and more that are focused on financial regulation and shareholder actions and the like. So next we turn to Joana Setzer, Assistant Professorial Research Fellow at the Grantham Institute on Climate Change and the Environment at the LSE, and the author or co-author of that one rather wonderful report that we love, tracking climate litigation around the world. Joana, to you.
Thank you very much, James. And well, I am reporting on and summarizing the discussions that we had yesterday in the workshop Climate Litigation and Politics. So the workshop was moderated by Jimmy May and Sam Adelman, and I will try to summarize those almost 2 hours of very fruitful, rich discussions in 8 minutes and leave no one behind. So I will also, if you don't mind, acknowledge the different ideas to those who made them, because I was just sitting and taking notes. They really brought all this rich material. So there was a general agreement across the group that first, litigation is a last resort. and that courts are no more than second best to resolve it. It happens that we have a big problem that needs to be addressed, and those who should be doing are not doing it properly, and therefore litigation became necessary. So with that in mind, and considering how litigation is increasing, we focused on one question that cuts across a number of the points that have already been made. And the question is, does this rapid increase in litigation undermine the separation of powers? Well, let me give you the short answer and then the long answer. So the short answer was no. Climate litigation does not undermine the separation of powers. But there were a range of different issues that we discussed. And in my attempt to summarize it, I will consolidate those in 3 points. So first point, the role of the judiciary. At the most fundamental level of the separation of powers, the judiciary has a role to ensure that limitation of human rights are justified. And this is what we saw in the Dutch Supreme Court decision in Agenda, in the Constitutional Court in Germany, and also in the decision in the Shell case in the Netherlands again. What Christina X said was that these cases are not threatening in any way the role of the judiciary. What they're doing, they're strengthening the separation of powers. Similarly, if you look from the perspective of those bringing the case, Filippo Fantozzi said that civil society is not trying to usurp the role of the different branches. On the contrary, civil society is trying to correct the functioning of the rule of law in a period of emergency. So climate advocates are simply inviting courts to fulfill their mission of corrective justice by restoring a balance between wrongdoers and victims. Second point, climate cases are not placing extraordinary asks. This is a point Christina made in her report, that in adjudicating these cases, the judiciary performs only an ordinary and appropriate function of determining whether the other branches of government are operating within the limits of the law. So Lucy Maxwell highlighted that climate litigation is not novel. And the only thing that is relatively novel is the subject matter that actually confirm a number of benchmarks, for example, the science and the political commitments that have already been accepted by the other branches. And it's applying this relatively novel matter in the context of existing well-established cases of action, such as constitutional law, statutory law, and tort law. Marta Torres-Schaub summarized this, saying that the judge is clearly not creating law. The judge is interpreting existing law and adjusting the law to the urgency of the climate emergency. Third point, perhaps the separation of powers is not such a problem after all. So Louis Cottes's view is that any constitutional state has sufficient checks and balances to control judicial abuse. We have a few examples. In Colombia, Ana Lucia Maya Aguirre reminded that courts are already influencing and changing the relationship between the powers. In South Asia, Lavanya Rajamani added that the judiciary is effectively occupying the void left by the other branches. Similarly, in Brazil, Alicia Morim described how courts are stopping the government from undermining environmental and climate legislation. And without courts, you could forget law enforcement in the Amazon. John Cerrone added an international law perspective, reminding that the decisions by the UN right bodies tend to blend judicial and legislative functions. And while these are not legally binding, UN bodies have a flexibility to go beyond what is legal required in the realm of best practices. And lastly, Laura Burgess pointed an interesting idea that climate justice and separation of powers do not actually match. So the notion of separation of powers was designed to deal with conflicts that are taking place at the national level, and climate justice is intrinsically global. This leads me to, and led us to discuss that beyond the matter of separation of powers, climate litigation is motivating a shift in power. What shift in power? Well, a shift of power to civil society and science. Frank Bierman spoke about how this is also maybe problematic because you need courts and lawyers to understand the science, and we need to account to the many imbalances between global north and global south. A shift of power to victims and communities that are now standing in equal footage with carbon majors and powerful states. Louise Fournier spoke about how thinking in terms of movement lawyering helps those lawyers and organizations bringing cases that reflect upon how litigation is set up and how litigation can actually empower victims and communities. A shift of power to the youth, who, as Mark Villers pointed, otherwise would not be represented by political branches, are directly influencing the outcome of litigation. A shift of power to NGOs and political actors who are not only bringing the cases and shaping public opinion, but Lavanya illustrated, they are in a position to identify evidentiary needs across jurisdictions. And lastly, a shift of power to groups backing the plaintiffs. As William Vasquez reminded, independently on whether the case was successful or not, they can go and affect political change. So I finish with 3 recommendations from our group. Esmeralda Colombo suggests that rather than justifying judicial lawmaking as a necessary intrusion in climate policy, we need to reconceptualize the separation of powers principle as it was conceived, a protection against autocracy. Perhaps, as Christina Eckes said, maybe we need more institutions that are able to protect citizens the right to a stable climate. In more practical terms, Andrew Jackson highlighted the importance of countries adopting national frameworks and that remedies are adapted to what feels safer for judges in each jurisdiction. Jimmy May provided examples where this could mean prioritizing the declaratory release or cases that involve less debate around the applicability of the principle of separation of powers. And Sam Adelman emphasized the importance of continuing this cross-pollination between courts, which we saw with the judges' panels. So Ivano, you asked whether the separation of powers is a cultural artifact, and if we can't do anything about it, if we should push litigation anyway. I'm sure that the discussion that we had in our panel will give you plenty of ideas to continue this reflection. Thank you.
Thank you very much, Joana. Wow, that's a great survey too, and lots of different perspectives coming in. I can't help being reminded, it's a long time ago, and some slightly older members of the panel might remember the epic debate between Ronald Dworkin and Stanley Fish on interpretation theory and jurisprudence. And it's just so relevant to the context in which the law is interpreted and where are the boundaries, how constrained is the judge when deciding a hard case or case involving this new discipline that's emerging, but by the legal system itself, by the norms and doctrines that existed before. How free are they to draw down from the outside context the means by which they can interpret the rules? Anyway, something worth returning to, I think. Now, our last summer up and reporter is Makani Mbenge from Professor of International Law and Director, Department of International Law and International Organization, Faculty of Law, University of Geneva. Makani, over to you, please.
Thank you very much, James. Good morning, good afternoon, and good evening to everybody. It's a pleasure to be here and to have the honor to make a report of the last workshop, which was on climate change litigation and environmental defenders. I can say that we had a very fascinating, stimulating, and thought-provoking discussion. We were very lucky to have with us some environmental human rights defenders who have been involved actually in climate change litigation across the world. And we had also the chance to have the discussion being facilitated by Professor Erin Daly and Mrs. Vivian Kristisevich, who both actually invited the participants to our group to focus on 2 aspects: enablers, one, and second, obstacles. So enablers, what would enable to protect environmental human rights defenders who are involved in climate change litigation, and what would also enable them to initiate and pursue climate change litigation. And then the second aspect in respect to obstacles was dealing with the type of barriers and impediments that environmental human rights defenders are facing when they want to engage in climate change litigation. But before I share with the plenary here the recommendations, the concrete recommendations that were made with respect to enabling and overcoming obstacles, allow me maybe just to point out that our group actually reached 3 levels of consensus with respect to environmental human rights defenders. The first strong consensus is that we all agreed that actually it is necessary, it is fundamental today to grant special protection to environmental human rights defenders, and in particular those who are involved in climate change litigation, because those people are more and more victims of harassment, defamation, and even in some cases murder. So that was the first strong consensus. The second strong consensus is that within our group, we all agreed that environmental human rights defenders are core actors in the fight against global warming, and that actually there cannot be effective actions for mitigation or adaptation without a full involvement of environmental human rights defenders in that field. And the third level of consensus that was reached within our group was that it is fundamental to promote and recognize certain environmental rights if we really want to protect environmental human rights defenders. So the right to a healthy environment, of course, was mentioned, but also some other interrelated rights like the right to water, the rights of indigenous communities, and some of the colleagues even suggested to think about a new generation of environmental rights, like the right to sustainable climate. And this is fundamental if we really want to protect and also to ensure that that environmental human rights defenders would be proactive. We need to strengthen those rights that I've just mentioned. All that to say that within our group, there was a strong, I would say, perception that the duty of states under the preamble of the Paris Agreement to actually respect, consider, and promote their obligations on human rights include the duty to respect, promote, and consider the rights, the fundamental rights of environmental human rights defenders: right to life, freedom of expression, right to access to justice, and right to effective remedy. And this brings me now to the recommendations. Our group really focused on trying to design concrete recommendations on how to enable environmental human rights defenders and how to overcome obstacles. And 3 sets of recommendations were made. Recommendations regarding the promotion of the role of environmental human rights defenders. Then a second set of recommendations relate to recommendations regarding the facilitation of the role of environmental human rights defenders. And last but not least, a set of recommendations regarding the protection of environmental human rights defenders. Let me come to the first set of recommendations, promoting the role of environmental human rights defenders in the field of climate change litigation. There, the group suggested 3 key recommendations. First, strengthening capacity building and climate education for both environmental human rights defenders, but also the judiciary. And all that in accordance with Article 12 of the Paris Agreement, which is actually insisting on capacity building and climate education. Second key recommendation in order to promote the role of environmental human rights defenders, strengthening the participation of environmental human rights defenders to climate decision-making process. And then third key recommendation, still to promote their role, ensuring effective access to climate information for environmental human rights defenders. So this is what we thought about in terms of promoting their role. Then let me come now to the second set of recommendations regarding the facilitation of their roles. And there were four key recommendations. First of all, building networks of environmental human rights defenders in order for them to share best practices and best strategies. Second key recommendation, developing resources, in particular financial resources, in order to allow environmental human rights defenders to overcome obstacles. Third key recommendation in relation to the facilitation of their role, reinforcing climate change litigation strategy, reinforcing the climate change litigation strategy of environmental human rights defenders. And last but not least, four key recommendations with respect to the facilitation of their role when it comes to climate change litigation, strengthening the accountability of environmental human rights defenders, making their actions more transparent, and also preventing that those actions are based on corrupted practices. And this brings me to the last set of recommendations that were made by our group, recommendations regarding the protection as such of environmental human rights defenders. And here there were three key recommendations. First of all, formulating both in international legal instruments and in domestic law, the duty to protect environmental human rights defenders and the duty to actually prosecute or punish violations of their rights. And one very good model is Article 9 of the Escazú Agreement on public participation. Second key recommendation, making sure to establish rapid response mechanisms to protect the violation of the rights of environmental human rights defenders. And here also, in the next months during the next MOP of the Aarhus Convention, such a mechanism will be put in place, very rapid response mechanism to protect environmental human rights defenders. And last key recommendation with respect to the protection of environmental human rights defenders, strengthening the independence of the judiciary. It was said in our group that actually separation of powers in some instances can really allow to protect environmental human rights defenders. So one way to protect them is actually to strengthen judicial institutions in many countries and guarantee judicial independence. So as you can see, it was a very fascinating discussion. And all that also to say that it's not about just building climate resilience today, but we need also to think about the resilience of those who fight for the climate. Thank you very much, Monsieur le Président.
Well spoken. And I can think of one or two foundations with resources that might want to respond to that kind of list of recommendations. And maybe also thinking, I know we have very little time here, but Christina, the World Congress coming up in September, there may be one or two things that we could put on the agenda for that at the IUCN. Now, look, we've got 5 minutes, just 5 minutes. Could we do a really rapid round the table assessment? Is there something that stands out in your mind from your own group or from the conversation we have just had, the reports of the other groups, that you'd just like to fasten on for the next thing you do in your working life or within the organizations you work? Is there something that leaps out at you? I've had some thoughts myself, but I wonder if I just might, begin. Well, let's begin with Christina. Is there something that you heard in your group or anyone you'd just like to highlight before we sign off and move on to the human rights panel?
Not necessarily topically, but we've got some feedbacks in our discussions from the participants that they thought this was a really important exercise and they would like to see more of it. That was just the beginning, and the judges really appreciated having that space to discuss these issues. So that was something I just wanted to share with the audience.
Got it. Something to recall. Yeah, the judges liked that experience. Some of them were felt difficult joining in a group like that. So the fact that they were able to do that, maybe we can keep going. David, you're top of my left-hand screen. Why don't you go next?
Well, just one thing that leaps out to me about the separation of powers is that there are different kinds of cases that raise these issues to a greater or lesser degree. And I think the thing that troubles people from separation of powers standpoint is when the failure is so massive and so wide encompassing, people get nervous about judges being the one to address that. And, you know, I think I just want to make that point. And you know, that's all just
the gap's too big. No, the gap, it can't fill. Yeah, I got it. Michael Gerrard, you're next on my screen. Anything that stands out for you you'd like to take forward?
Being in the United States, where we have a dysfunctional Congress and a court system that so far has refused to grapple with these issues, it was enormously encouraging to see so much positive activity happening all around the world. And it encourages me in the thought that maybe there are ways to do that in the United States, particularly at the state level. But I'm very encouraged by what I've heard in this conference.
Good, good, good. Encouragement and hope are important ingredients in this whole process. Joana, you're in the middle of my screen now. Why don't you go next? Anything that stands out from your fantastic group? You had really good comments.
Yeah, well, I think what made me think is that, of course, we are in our group and probably people who are attending this event, we're all very much already convinced of what needs to be done, of how this is all important. So for me, the main question is, this is still a bit too niche. And what I wonder and want to see is how it will get mainstreamed, how in a few years, climate litigation is not going to be such a big deal. It will be the normal. And what's being asked is not going to be a shocking, and these decisions are not going to be groundbreaking anymore. It's going to be just what we are going to hear and see happening. So, yeah.
The proper process of the application of the rule of law to things that matter. Makani, you're next on my screen. Anything from your group or from the others that you've heard in this conversation that makes you think, I've got to do that?
Yes, well, something I was very pleased to hear is that, you know, those who are engaged in climate change litigations are really a diverse category of actors, and that we need to go beyond the usual suspects when thinking about climate change litigations. Environmental defenders are all over the place, and so we need to have also a broad perspective to the protection. You know, we tend to talk a lot about domestic courts, but climate change litigation is going also to happen a lot in investment arbitration. So we need also to think about investment agreements protecting those who will fight for the climate there. Thank you.
Whole topic of conversation we might want to have another time. Yeah, investment agreements, permanent court of arbitration in The Hague, very interested in receiving cases like this. Lots of trade disputes that need environmental interventions. Yeah, something perhaps to return to there. Mike, you're finishing us off. Something that leaps out from the conversation that you had in your group or from the other groups.
I would just note that there was a great deal of recognition that, you know, science does not provide the answer to these legal cases. It does provide a lodestar, and at the very least, it provides necessary guardrails. And those are the guardrails that governments and corporations have to stay within in order to even have a chance at being compliant with basic notions of justice, fairness, and equity.
And you also made that critical point about how you communicate and the different languages that must be used. You know, there's an evidence language that works in a courtroom, and there's a different language that works in the persuasion of other key actors in society. And the scientists have had, you know, a major challenge doing that in a way that makes them feel that they're not in any way breaching their own standards of behavior when it comes to describing the phenomenon of climate change. Look, that was brilliant. Thank you so much, everybody, for all the work that was done. And, you know, further apology for the technical difficulties you probably had to endure, and sometimes quite late at night somewhere in the world. But we have a great report back, lots of good material to use, and we will use it wisely. So thank you very much. And now we'll have a small turnaround and go to the panel on human rights.